Good afternoon, Chief Justice, and good afternoon to the Commission.
Just keep it on. You don't have to switch it off again. You hold a BProc degree.
That is correct, Chief Justice.
Since when have you been an attorney?
Since 1985.
That's about what?
31 years.
21 years.
31.
31 years. What kind of practice did you have?
It's a general practice.
With special emphasis on? Or constituting mostly what?
It's mostly bodily injury cases. Then there would be litigation as well. That's correct.
Any criminal work?
At the present moment, it's very, very less of it.
You have acted as a judge, is that not so?
That is correct.
For how many weeks?
At the moment, it's 89.
9.
9.
How did you find the acting experience? Was it just too difficult for you? Or maybe initially, and then as you grew into it, you found it relatively easy? Just tell us what your experience was as you were acting.
Yes. I would say, Chief Justice, at the beginning, it's a bit difficult, not by way of the work itself. It's more particularly coming from the ranks of attorneys. You seem to be second-guessed in everything that you do, and it takes a bit of time to establish yourself. But once well established, then the flow is okay. As we speak right now, those challenges where you second-guess everything you say seems to be taken with a pinch of salt is gone.
Did you struggle at any stage with handing down judgments timelessly, or was it never a problem for you?
It actually has never occurred.
What is the longest it has ever taken you to have a judgment delivered?
Less than 2 months.
I beg your pardon?
Less than 2 months.
Less than 2 months.
That's correct.
Very well. JP?
Thank you, Chief Justice. Mr. Mbongwe, good afternoon.
Good afternoon, Chief.
You've responded to a question to the CJ that it's 89 weeks. I think it's 3 weeks in addition to the period set out in the spreadsheet in front of you. And that's because of these are 3 weeks you perform service now, towards the end of the term. Am I correct?
I don't know.
My spreadsheet says you've got 86 weeks. Yeah.
It would have been 83 at the time we submitted our applications.
Yes.
Then I went in at that stage for the term to end.
You're too soft, Mr. Mbongwe. Not everybody can hear what you're saying.
It was 83 at the time we submitted applications. That was the beginning of August.
Yes.
Then there were the additional weeks. I think I can...
I'm not disputing it. I'm just saying the additional weeks to my spreadsheet, you acted until the end of the term.
That's correct, JP.
Right. Now, of all the candidates, you're the one who's acted the longest to the candidates that are appearing here. 89 weeks. That's 1 year, 8 months?
9 months.
1 year, 9 months.
That's
yeah.
correct.
Now, I confirm your answer to the CJ that you've not had problems in writing your judgments. I've never had to confront you about a judgment. You've acted in difficult work areas. 23 weeks in the unopposed court for a black practitioner, sole practitioner. How did you manage that?
JP, the unopposed court is indeed the heaviest. It has been the heaviest, and
commissioners are complaining they can't hear you.
Oh,
you're too soft.
Yes. The unopposed court is indeed the heaviest. I regard it as the heaviest court. It does take a lot of time. The reason why one copes is to be ready by the time you go to court. Time will be consumed if one were not to be ready. Expect counsel to take you through the papers. But if one has read, you have specific things, you can allow them to speak, and at some stage you ask them to address you on specific things where it's a matter of concern. Yeah. And that facilitates. You are able to shorten and control the proceedings.
Yes. And you've not struggled in that court?
Not at all.
Right. You've also done work in the opposed motion court as well as in the urgent court. I see 4 weeks in the urgent court.
That is correct.
Good. Now, it's the second time you come before this commission. You came last year. And I just want you to take the commission into your confidence. When you came last year, issues had been raised against you by the Johannesburg Bar Council. And after the interview, I said to you, I'm still going to offer you acting appointments to see if what happened will happen again.
That is correct.
Can you take over from me from now and just tell the commission what's happened since until now?
Thank you, Chief Justice. Yes, thank you, GP. The advantage of receiving comments, there are times when you act, you are really involved. You seem not to appreciate everything that other people see. The advantage of those comments was one is able to sit and reflect and see. Remember that one will always have in mind the fact that you're dealing with the public. And if there's any area of concern that is being expressed, one takes that to heart. Since October, I have drastically tried to deal with the temperament. I have tried to allow people to speak, that without compromising the control of the proceedings, but be less involved and only speak where it's necessary. And quite frankly, I must say, JP, it has worked. People are free to talk, more accommodative, even in matters where you realize that this I shouldn't be allowing because of time constraints. It does not bother me anymore. Give a typical example where a case, you've read the file, you indicate to a person that maybe you need to supplement the papers and what have you. I'm no longer rushing time. I would tell a person if it's a Monday, I'll be sitting again on Wednesday, I'll be sitting again on Friday. Why don't you go and prepare your papers, supplementary papers, and come on any of those 2 days? And the cooperation of people. They would come in most instances. They would come in with the very same day and say, we've managed to get the supplementary documents, there they are. And it really facilitates, everybody is free to express themselves, and everybody is willing to participate. And that actually lessens the time, unnecessary wastage of time.
So you've not had any recurrence of the incidents that led to the discussion of those issues in the last interview this time around?
Not at all.
And you say the additional time of acting since the last interview has been well used in that regard.
I've actually enjoyed it, especially when one monitors one's own conduct and see that is there a change. And I've really found that it has worked positively.
You've submitted a list of judgments you've written. I'm counting 65. Is that correct?
That is correct. I should remind the JP, I did indicate that it could be more. It's just that there are judgments that were not sent to me. Others that were sent, I couldn't find in my iPad anymore. It will say that they are not been downloaded from the server. So it could be another maybe 5-6 judgments that have not been disclosed.
And you've traversed a wide spectrum of areas of law in the judgments you've written. Any difficult area you've encountered?
I think I did actually indicate in the application form, JP, that it's a difficult question if anybody were to say what is my area
Yes.
of preference and what have you. I adjust and accept any challenge, and I've never really struggled to get to grips with any matter so far.
Yeah. And I think you're the only candidate who's also done criminal trial work in this whole group. I think you've done a total of 9 weeks.
I have.
Is that correct? And you feel this has adequately equipped you to get the nod to be appointed?
I think I'm well equipped.
Thank you very much, Chair.
Thank you, JP Mlambo. MEC?
Thanks, Honorable Chair. I had an opportunity to interview the candidate last time, so I have no new questions, Chair. Thanks.
Thank you, MEC. Commissioner Nyambi.
Thank you, CJ. It's only one question from my side. I've gone through what was said previously. It's in relation to the number of attorneys that you have produced. If maybe you can be able to explain them in terms of figures in relation to gender. It's almost 10.
It is. In fact, the females would be about 4. They're all in Johannesburg.
Thank you, CJ. That was the only question.
Thank you, Commissioner Nyambi. Commissioner Helens.
Mr. Mbongwe, I've taken into account what JP Malamba has asked you. I've just made a quick calculation. Since you were last here, I think you have acted for 15 weeks. That's correct. So from October last year to now, you've acted for 15 weeks.
16.
I'll take 16. So therefore, prior to that, if you've acted in a total of 86 weeks,
Yes.
you would have acted for 70 weeks prior to October last year.
What happened when I was here, the interview last year, by the time I submitted the application, it was 62 weeks. And there was still 7 weeks to go.
Yes.
before
I'm
the
not
term ended.
quibbling with the figures. The point is that you've acted for 16 weeks since you were last year, and prior to that, you had acted for 70 weeks before coming here in October last year. The precise number doesn't matter. The ratio matters as far as I'm concerned. You agree?
I'm not quite with you.
Okay.
Commissioner
Start
Evans.
again. Prior to October last year, you had acted for 70 weeks, up to October last year. Correct?
Yes.
And then since October last year, you've acted for another, I had it as 15, you say 16, I'm quite happy to take 16. Right. Now, after having acted for 70 weeks, the comments of the GCB at the time were very negative. You're aware of what they were, and they're in the transcripts. The GCB, dealing with your temperament, you were interrupting counsel, you were rude to counsel, and the GCB summed it up like this: a number of qualities that one would expect from any judicial officer are not exhibited by this candidate for the reasons set out above. The message which the appointment of this candidate would send to the community, but the legal community will therefore regrettably be a negative one. I'm quoting from the transcript. You remember those comments?
Yes.
You
So
remem-
save that to use strong words like rude. I don't remember seeing such a word.
Well, you remember the comments of the Supreme Court of Appeal in the Naidu versus Minister of Police matter
Yes.
about your conduct.
Yes.
I won't read it out again, but the last bit of the Supreme Court of Appeal's comments are: even more disconcerting were the numerous unwarranted interruptions by the learned judge when he wrongly prevented or restricted at critical stages of the trial the appellant's legal representative when she led or cross-examined witnesses. To compound matters, some of the interventions bordered on discourtesy and cynicism towards the witness, and counsel were not spared either. Now, the succinct question is this. If you behaved like that as recently as just before October last year, how in 16 weeks do you suddenly turn into a model judge and see the error of your ways and cure them completely? Did you not see in the first 70 weeks of your acting that you were behaving wrongly? Didn't occur to you?
Commissioner Helens, the reality is, after that interview, I did have a discussion with the judge president. And with those experiences, I'm sure if there was any complaint that subsequently followed, the judge president would have been aware. He had said it actually in this commission, that I know the correspondence that he exchanges or he receives from other legal bodies. I have not been called by the JP so far to come and account and say, you undertook this, this is what we discussed. It has not happened.
I don't think you've answered my question. At the time that you behaved in the way that the GCB has criticized and the Supreme Court of Appeal has criticized, you didn't feel you were behaving wrongly at the time. Is that correct?
It's more a subjective matter, actually. I could be thinking that I was actually behaving properly. Somebody else would see it the other way around. So what was important, and is still important, is the fact that the comments drew my attention to certain types of conduct. And what is important as well, that has been corrected.
That's what I'm interested in.
There's not been any similar.
That's what I'm interested in. People don't often change very easily, and I want to know how you achieved this, what would appear to be a dramatic change in demeanor.
That's very subjective, Mr. Helens. All I can say, successfully so, it has changed. JP, I'm sure would have called me. That has not happened.
Can you answer a different question, please? What is your judicial philosophy?
Well, we are in a constitutional democracy where the rule of law is actually the order of the day. And the judiciary, obviously, as the custodians of the Constitution, we look at all aspects as long as the rule of law is upheld in whatever circumstance. I think the strive or the focus is on the uphold of the rule of law.
Can you expand upon what you believe the doctrine of the separation of powers means?
Yes. If you refer to the cases that I've attached, you would find that there is the matter of the CETA versus Mtia dynamics. It is clearly set out there, but for the benefit of saying it in public, it would be the rule of law. One, firstly, should I say that the government consists of three components. A simple way of displaying the separation of power, I would put it this way: it's the refrain by each of the three components from intruding into the area of operation of the other. That would be summing it up. Wanda, do you want me to explain it further?
You choose the way you answer the questions, not I.
Prof.
Thank you, Chief Justice. Good afternoon, Advocate Mbongwe.
Good afternoon, Professor. Commissioner.
Thank you. In your questions, in fact, in your form, you were once in partnership with Moody and Robertson attorneys. And
That is correct.
And your partnership did not last long.
Yes.
It was a year. And when you answer as well the other question, that you have learned so much from that partnership, is there anything that you can share from that experience?
Yes.
Or what are the challenges that we were faced with that prompted that short stint of that relationship between you and that other law firm?
I will try and answer this question, though I do not, quite frankly, feel that I'm free to do so, because it would mean that I should take the matters of the partnership I was in and bring that they are not here to answer for themselves. Basically, there was no fight between me and the firm. We differed on certain agreements. For instance, I pushed for the bringing in of more black people. I was the only black partner. And at the beginning, it was agreed, and I was given the task to try and bring in black people. And I actually specified that I am here, my preference would be to bring in 2 black women to join the partnership. That was the agreement. And when it did not, 6 months down the line, it looked like nothing is happening. I then raised it in a partnership, discussed it, and there was the issue of the purchase of shares. To me in my case, it was easy. I had a practice, so I did not really have to pop out money. I was bringing my practice. Both firms were audited. Now, if you think of bringing new people, I was not looking at anything. I was thinking that the grown-up people, so to speak, would be settled where they are. So we're looking at basically young people. Now, the extension of the mind to say that it would be impossible for those people to raise the capital that might be necessary for them to purchase shares in the firm. We had to devise a strategy. I said, I, for one, with my 10% holding, I'll be prepared to give 2 away. Is there any other partner who would be willing to give shares? But now the effect of that was it wasn't enhancing the rating of the firm, the BEE rating of the firm. It was basically going back, which basically meant other partners should actually give shares. And we could not move any further than that. And to me, I was not. I must say that there was pressure as well. I'm a senior attorney. There would be younger people, younger attorneys, who were not quite about me being there. And obviously, we would, I don't know if you'd know this, the city of Johannesburg was the client of the firm. So the differences were more principle than anything.
Thank you, Prof. Minister.
Thank you, Chief Justice. Counsel, I want to hear, based on your own experience as a practitioner, what your view is about whether it's a fact or a perception, the existence or prevalence of the phenomenon of forum shopping and the extent to which it impacts negatively on the image of our justice system. If you could comment on that.
Minister, I'm going to ask a question. Forum shopping could basically mean more than one thing. Would you be more specific as to which aspect you're referring to so that I'm clear in my answer?
The intention was to give you a free license to say anything that comes to mind about it.
Yes.
Let's try, and if you have difficulty, maybe we can narrow it down somewhat.
If I may, I would ask you to narrow it.
Okay. It has come in different forms. In some instances, there is a view that because of lack of confidence in transformation of the judiciary, certain litigants opt not to use the mainstream justice system through the courts and opt to arbitration as a way of resolving their disputes outside of the mainstream justice system for that reason. It's also come in the form of certain litigants or their legal representatives finding a way to choose who they appear before in the mainstream courts by, in some form or another, being privy to who is going to be the judge sitting in their matter, finding a way to rather have the matter come up on another day when a different judge would be sitting. Those are just two examples that come to mind. Are you familiar with any such phenomena? Have you ever come across those perceptions, if not facts? And what is your take of it?
Yes, thank you, Minister. It is a fact that people where confidence is lacking would rather seek different avenues of resolving matters. I do not particularly think that it has any really impact on the courts. I'm not aware of a situation, or I have never come across a situation where a matter that was allocated to me was conveniently settled. As a matter of fact, I should say that I have come across matters that even at face value I thought were very much involved, and at short notice. Again, I'm going to refer to Commissioner Helens. Once I was sitting in the opposed motion court, a matter that was for some reason not on the roll was taken to the senior judge in that particular week, and the senior judge referred that matter to me. Now, you're faced with a situation where you have to decide, and it was an involved matter. I did not really begin perhaps to feel that counsel could go away or anything. I say I have not experienced that. Just to come to your question how that affects, it's more a matter of people's, the depth of their pockets. Those who believe that they can afford the private venues, and individuals who will be hearing those matters are free to do so, but the majority will remain. The other aspect is I still believe, with the presence, that forum shopping, by and large, is still more reliable. You'd see that by decisions taken. I referred earlier on to the matter of Mtia, which was taken on a private forum, and ultimately, because both sides were not happy, they even fought just to bring the matter for judicial review. I was happy to listen to all those things, and the reason why, having chosen a different avenue, they ultimately came back to the judiciary. It is concerning if people would prefer not to come to the courts and prefer different avenues. But those areas, those avenues, are not without problem themselves.
Clients seem to choose who represent them in part based on the kind of reputation that the specific practitioners precede them, whether or not that reputation is a true reflection of their competence or otherwise. Is there anything that can be done or that should be done to ensure that there is even or equal access to lucrative work across the demographics of society in a manner that overcomes prejudices, whether they're based on gender or race?
Honorable Minister, it would be a difficult question to answer, in the sense that people make their choices. And if people with deep pockets decide on following any particular course of action or avenue, it cannot be discouraged. It would be, to me, a futile exercise even to try. It is a situation that cannot be controlled. It's a decision that is taken by individuals.
My third and final question, through Chief Justice, relates to the perceived or actual creeping in of impropriety within the profession, or pre-existing, continued impropriety, specifically that is calculated to fleece the state through malicious and opportunistic litigation, which sometimes even borders on fraud. Should the judiciary pay attention, intervene in cases which present themselves as such, or is it the responsibility solely of the state, or shall we say government specifically, as the arm of the state who stands to be prejudiced? Do you think that the judiciary should be involved at all, in your opinion?
Yes. I should think that it's more an aspect that should be attended to by the state. I say this having in mind the separation of powers. The judiciary, the judiciary's intervention is actually limited until such time that those matters are brought. Surely the other arms of government would not be happy that these are matters that are the reserve of the state, and suddenly the judiciary is rearing its head.
Thank you, Chief Justice.
Thank you, Minister. Commissioner Singh.
Thank you very much, Chief Justice. Just two short questions, Mr. Mbongwe. Your practice, is it still functional, and who manages it when you're not there? Firm of attorneys.
It is, there are 3 qualified attorneys who are in the firm.
So it's a fully functional practice even when you are absent.
Yes.
Right, thank you. And then just on, I'm looking at the transcript the last time in response to a question by Commissioner Helens. You said, I think I allowed myself to be nervous in light of the 6 claims that were contained therein. You went further to say, but chiefly it was the first civil trial that I did wrong, and what I did wrong was to allow my nerves to take the better of me. You still stand by that?
That is correct.
And you also stand by the fact that, as we heard from the JP, that you've corrected this temperamental, quote-unquote, issue in the last year or so.
I have indeed.
Thank you, Susan.
Thank you. Advocate Ngozi Thomas.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Commissioner.
Let me find out from you what your view is as regards to the role of the courts to develop the common law. Would you say that function is an obligatory one or discretionary one?
I would basically say it would be circumstances to take that as a concerted exercise. I think wouldn't be proper unless such time that we see that there is a demand to sort of undertake that course. It should not. So whether it's discretionary or not is difficult to say. It's a course that is open and should be followed as and when circumstances so demand.
What is your authority for that proposition? Why? What's the basis of that answer? Why do you say, what are you saying? Are you saying it's discretionary or mandatory? I didn't quite follow the answer. Please, Judge.
Yes. If you say it's mandatory, so we don't have a choice. It's something that has to happen. I take it, the Commissioner, you use the word discretionary because there is also that possibility. So I'm saying unless we have circumstances or a frequency of circumstances that warrant that there be such development, even in the absence of any, it would save resources not to channel every resource or energy in that direction. The development will always be necessary. I do not really believe that there should be certain instances, particularly in the area of law, that should be allowed to stagnate.
What does the Constitution say in a case where a matter comes before you and you form the view that the common law does not go far enough? In other words, it does not accord with the provisions of the Constitution. What are you as a judge expected to do in such a situation?
Commissioner, without making this a debate, I think it comes back to what I said. It would be circumstances that direct you in that direction. Then you would say, okay, we need to develop this particular area, and that is when you'll do it. But whether you just take circumstances, say everything taken into account, there is a need to go this route, then you're focusing on something that might not necessarily be relevant at the time. The law develops because of events.
Thank you, Chief Justice. I don't think I can take it much further than that.
Thank you, ma'am. Your excuse, sir. Thank you very much.
Thank you.